we continue our discussion on torts with negligence and strict liability. What are our learning objectives with this particular lecture? Well, when we finish, you'll be able to identify the elements of negligence, recognize the doctrines that help a plaintiff establish a cause or a case of negligence, recall the defenses to a claim of negligence, and identify the elements of strict liability. As I'm sure you recall, unintentional torts are called negligence. Negligence is a behavior that creates an unreasonable risk of harm to others, or a failure to exercise reasonable care to protect another's person or property. The elements of negligence are duty, the standard of care a reasonable person owes another, also called the reasonable person standard. Now, duty comes from first the reasonable person standard. How would a reasonable person behave in a situation to prevent risking others unduly? For example, if you can drive, the question I would have is, can you drive your car on the sidewalk? The answer should be yes. Why don't you drive your car on the sidewalk? The answer is, if you did, you place pedestrians, people walking on the street, at an unreasonable risk of harm. So that's the reasonable person standard there. The second place the standard comes from, your duty comes from, is the law. In certain situations, the law specifies a person's duty. Going back to driving your car, if you have a driver's license and you drive, can you drive your car on the sidewalk? The answer is yes. Why don't you drive the car on the sidewalk? Because it's illegal. The law says you have a duty not to put pedestrians at an unreasonable risk of harm. Now, a third source of duty is your profession. There's something called a professional duty. Now, the professional duty applies when someone is acting with regard to something that they have special training in. Whether you are a doctor, a police officer, an EMT, an engineer. For example, let's say a doctor witnesses a car crash. Car is on fire, so what does the doctor do? The doctor runs to the crash, grabs the driver out, yanks him out the window. Goes back, gets the next person, pulls them out the other window. Now, when they yanked the driver out the window, they pulled very hard, very quickly. They injured the driver's neck. The doctor could be sued. Why? A doctor has special training that tells him or her that before you move a person who's been in an accident, you have to stabilize their neck. By contrast, a layperson in the same situation, pulling a person out of a burning car, injuring their neck or back, would not be liable for anything. Why? Because they lack any special training. So they're not held to a professional standard. The second element for negligence is breach, specifically a breach of duty or a failure to live up to the required standard. Now, this one is pretty much self-explanatory, right? If there's a standard of care, you have a duty to honor that standard. If you fail to honor the standard, honor the requirement, you are in breach. Element number 3 is causation. There are two types of causation that must be proven: actual cause and proximate cause, but we'll talk about that more in a minute. The fourth element is harm/damages. In order for someone to cover in a negligence claim, actual harm must be suffered. Actual harm must be suffered. No harm, no foul. Now, as with most things that I give you rules about, all 4 elements are required to establish negligence: duty, breach, causation, and harm. Say it with me: duty, breach, causation, and harm. Let's talk about causation just a little bit. Now, as I told you, there are 2 types of causation that you have to prove. The first is actual cause, also called cause in fact. The plaintiff must prove that the defendant's breach of duty resulted in the plaintiff's injury. Now, this is a but-for test that you have to apply. Specifically, but for the defendant's breach, the harm would not have occurred. Now, sometimes someone fails to do something, and as a result of that failure, a person is injured. And that's why the but for with the actual cause is so important. Let's say you live in Queens. You have a house that's on a hill, and because everybody in Queens has 2 or 3 cars, you have just enough room to drive up your little driveway. You can't turn around. So you park your car, you go in the house, you go to sleep, you wake up a little late the next day, you're late for work, so what do? You jump in your car, and you start to back your car out of your driveway. As you get to the street, you go over a little bump, boom, boom, and you hear a woman start yelling and screaming, "Oh my God, my baby." You jump out the car and you find out you just ran over a baby's head. You killed the baby. Now, here's the thing. What did you fail to do when you were backing the car up? You failed to look over your shoulder to see where you're going. Now, here's the question. Did your breach, your failure to look and see where you were going, cause that baby's injury? The answer is maybe, maybe not. Now, if the baby was small enough and the baby was bent down to pick up a ball, even if you'd looked over your shoulder like you're supposed to, even if you'd looked to see where you're going, you probably would have hit that kid because you would not have seen him anyway, right? In that case, you could not prove causation. You wouldn't be liable. The second type of causation that has to be proven is proximate cause or legal cause. Proximate cause or legal cause. Specifically, the plaintiff has to prove that the defendant was under a legal duty to protect the plaintiff from the type of harm the plaintiff suffered. Let's go back to that early example I gave you about driving on the sidewalk. If you were to drive your car on the sidewalk as opposed to in the street and you ran over a person, did you have a legal duty not to run over that person? The answer is yes. A law is in place prohibiting you from driving your car on the sidewalk for the sole purpose of protecting pedestrians. So the plaintiff would be able to prove his or her claim. Now, as with all things in the law, why do you go to court? You go to court to get paid. You go to court to be made whole, right? Now, this is where damages come in. Now, some of these things you've heard before, and you're going to hear them again, because damages are damages. But these are the types of damages a plaintiff can recover if the plaintiff proves negligence. First is compensatory damages. Compensatory damages are intended to reimburse the plaintiff for his or her losses. Compensatory damages are intended to make the plaintiff whole or to put the plaintiff in a position he or she would have been in had the negligence, had the harm never occurred. Second type of damages are punitive damages. Now, I'm sure you remember the word punitive means punishment. Punitive damages are designed to punish the offender and to deter others for committing the same type of negligence. Now, they're usually reserved for cases of gross negligence, right? Or involving a defendant's extreme and reckless disregard for the life and property of another. Now, an example of this might be, let's say you just bought a new machine gun and you're sitting on a crowded train with your friend and you decide that you want to show them how good the gun works. So you just start pulling the trigger. Now, you're not intending to shoot anybody. You don't even think about shooting anybody, but you have total disregard for the risk that you're putting others in, the other people in the car with you. So if you were to hit them, that would be gross negligence. Now, we got a couple of plaintiff's doctrines, right? We start off with res ipsa loquata. Res ipsa loquata. Now, this permits a judge or a jury to infer that a defendant's negligence caused a plaintiff's harm, right? And this is applied in cases where there is no direct evidence of the defendant's lack of due care. Now, when there's no direct evidence, a few things have to be proven. First, the event was of a kind that ordinarily does not occur in the absence of negligence. Second, other reasonable causes, including the conduct of third parties and the plaintiff, have been effectively ruled out. And third, the indicated negligence was in the scope of the defendant's duty to the plaintiff. Now, you guys are probably too young to remember, but several years ago, we had a situation with Con Edison and manhole covers blowing up. If your car was parked over a manhole cover and the manhole cover blew up, you don't have any direct evidence showing that Con Edison did something to cause your car or the manhole cover to blow up and destroy your car. But here's the thing. Do manhole covers blow up without some sort of negligence? Generally, no. Who is responsible for manhole covers? Usually Con Edison. And if you can show that there was no third party that rigged it to blow and that the plaintiff didn't rig it to blow, you can conclude, number three, that it was caused by Con Edison. It was within the scope of Con Edison's duty to the plaintiff, mainly to keep the plaintiff safe from exploding manhole covers. That would be how you would prove res ipsa locuta. Now we have another one called negligence per se. Per se, once again, means in of itself. This permits the plaintiff to prove negligence by offering evidence of the defendant's violation of a statute enacted to prevent certain types of harm. Now, in order to claim negligence per se, you must prove that the defendant violated a statute that provides a criminal penalty, but not civil penalties. 2, cause harm to a member of a class originally protected by the statute. And 3, have a plaintiff as a member of the protected class by the original statute. Now, a real easy one is speed limits. Speed limit says how fast you have to drive your car. If you drive faster than the allowed speed limit, and as a result of speeding, you injure a person or that person's property, they can prove negligence per se. Why? You violated a statute, the speed limit. Now, with speed limits, contrary to popular belief, there's a criminal penalty for getting a ticket, not a civil penalty. The harm caused, whether it's a driver or pedestrian, was of a class originally protected by the statute. The reason why you have speed limits is so that you don't have accidents injuring people or their property. 3, you have to prove that the plaintiff was a member of the protected class by the original statute. Well, the purpose of the statute was to protect people or their property from speeding drivers, right? So if somebody speeds and hits a car, you can sue them on the basis of negligence per se without proving anything else. What are our defenses to negligence? First defense is contributory negligence. This allows a defendant to avoid liability by showing that the plaintiff's own conduct contributed to the plaintiff's harm. I'm driving down the West Side Highway going 90 miles an hour. I'm in the right side lane, you're in the center lane. You decide that you want to change lanes. You fail to signal. I hit the back of your car. Now, you can sue me for negligence per se, but I can counter and say that you contributed to the harm that you suffered. How did you contribute? By failing to signal. You failed to let me know you were changing lanes, and you failed to give me the opportunity to slow down. So you contributed to the harm that you suffered. is comparative negligence. This allows an apportionment of liability between the plaintiff and the defendant according to the degree of responsibility each bears in the plaintiff's harm. Going back to that previous example, I'm driving down the West Side Highway 90 miles an hour. I'm in the right lane. You're in the center lane. You change lanes without signaling. I hit the back of your car. Now, under comparative negligence, am I responsible for your harm? Yes, but you're also responsible for part of your harm. So what the court has to decide is how responsible you were and how responsible I was. If the court said you were 50% responsible for the harm that you caused, or that you suffered, I would only have to pay for 50% of the damages, not 100%, because you also bear some responsibility. Now, the third defense is an assumption of risk. This allows a defendant to avoid liability by showing that the plaintiff willingly engaged in an activity where the harm was foreseeable. Now I'm going to say this again. Willingly engaged in an activity where the harm was foreseeable. My favorite example is paintball. If you go to skirmish, which is in Pennsylvania, and you play woods ball, you assume the risk of any injuries you sustain by running around in the woods. That means tripping over branches, tripping over rocks, getting bumps and bruises, right? Those injuries, those harms were foreseeable. When you go to the amusement park, having a heart attack, going into a seizure, those risks are foreseeable, right? So with assumption of risk, that's what they're claiming. You knew what you were getting into and you chose to do it, so they're not responsible. Now, you have a couple of special defenses to negligence that include Good Samaritan statutes and establishing a superseding cause. We're going to start off with Good Samaritan statute. Good Samaritan laws provide legal protection for ordinary people who step up to help in an emergency. They're meant as a way to encourage those who aren't in the healthcare profession to act by removing the threat of legal liability for the injuries or other problems that could result from their intervention. You see an accident, you go to help, you're well intended, you save somebody's life, but let's say in saving their life, you break their ribs. In saving their life, you break their arm. Good Samaritan statutes would stop them from suing you. The second is a superseding cause. I like that word, superseding cause. The term superseding cause refers to some event that occurs after the initial act that caused an accident or some other injury. A superseding cause, also known as an intervening cause, may be proven to have substantially caused the injury. Let's say you're driving down the West Side Highway, my favorite road, and you were talking on your phone, which you're not supposed to do. Your phone drops from your neck, so you bend down to pick it up. You take your eyes off the road. You crash into the back of a car. The car goes across the highway. It causes a truck driver to lose control. The truck driver loses control, hits a pole. The pole goes down and hits another car. It's a 25-car pileup caused by you. Well, the truck driver's mother was home watching the news when she saw her son's truck crash and she had a heart attack. Well, even though you were the cause of the crash, she could not sue you for negligence being the cause of her heart attack because there are too many steps in between, right? And really, what caused the heart attack? The news coverage of the accident. So that is what she could sue the TV, but not you, because there was a supervening cause that caused her injury. strict liability, or liability without fault. The law holds an individual is liable without fault when the activity in which he or she engages satisfies three conditions. It involves a risk of serious harm to people or property. It is so inherently dangerous, it cannot ever be safely undertaken. It is not usually performed in the immediate community. Now, the example I have of this you see on the screen: demolition, demolition, demolition. When you go to blow up a building, you're using explosives. Things are crashing, debris is flying. Because this is so inherently dangerous, even if you take every possible precaution to prevent people from getting injured, let's say the safety zone is 200 meters, but you move it back to 400 meters, if one pebble flies from that debris and hits anybody, you are liable, just because blowing things up is inherently dangerous.